Well, hello, everybody. I want to welcome you to the seminar that we're about to enjoy together today, presented by the Melbourne Social Equity Institute, as well as being part of our Mental Health and Society seminar series for 2021. Before I say anything else, I'm sure that together we want to acknowledge the country that we're on. So we're on the lands of the Aboriginal people who have been custodians of this land for thousands of years. And I'm speaking from Wurundjeri land today. And together we want to acknowledge and pay our respects to their elders, past and present. And we want to acknowledge Aboriginal leaders across the uni and pay respect to Aboriginal people present with us today in this seminar. If I can just explain what's slightly different about today's seminar compared to some in our series. Today is a book launch as well as a seminar, so the format's slightly different. First of all, we'll have Professor Bernadette McSherry introducing the excellent text, Mental Health Law, Abolish or Reform, a book by Dr. Kay Wilson, published by Oxford University Press. And Kay's then going to speak to us about her research. And then there'll be time for some Q&A. And for the purposes of today, we'll use the chat function mainly to register our questions, but you can have an opportunity to, re-present your question if I invite you to do that as part of the Q&A section. But if you flag that you've got a question in the chat, that would be really helpful for a group this size. As well, because it is the launch, it's a celebratory event. It'd be lovely if people want to stick around for a little longer after the formal proceedings and the presentation for some Q&A and catch up with friends and families and colleagues. So yeah, please feel free to stay on the Zoom to chat and congratulate Kay. And just to point out too that the session is being recorded today and will be made available via the Institute's website after the event. So we'll stop the recording at that informal point later on. So without any further ado, I'd like to introduce Bernadette. She may not need an introduction to this audience. And Bernadette, a lot of people would know, is an emeritus professor at the University of Melbourne, having served as the foundation director of the Melbourne Social Equity Institute from 2013 to mid-2021. Professor McSherry has published very widely in the fields of criminal law and mental health law and was awarded a prestigious Australian Research Council Federation Fellowship in 2017. From March 2019 to February 2021, she served as Commissioner for the Royal Commission into Victoria's mental health system, a very, very contributing member of our academic community, and we'd really like to welcome you now, Bernadette, to speak.
Thanks very much, Bridget. I'd like to acknowledge the Bunurong people, the traditional custodians of the land from which I speak to you today, and pay my respect to elders past, present and emerging. I think such an acknowledgement is particularly important given the topic of today's book launch. Non-Aboriginal people like myself have much to learn about social and emotional well-being. That's the term currently used to recognise connection to land, sea, culture, spirituality, family and community. And now more than ever, those connections should be at the forefront of our minds. Well, I'm delighted to have been asked to launch Dr. Kay Wilson's book today. I first met Kay back in, I think it was 2009 at Monash University, and she'd left a very prestigious law firm. For the realms of academic life, she decided to work as a part-time research associate while balancing the demands of a young family. And it was clear from those early days what an amazing researcher and deep thinker she is. And I was very fortunate to be a co-supervisor of Kay's doctoral thesis upon which this book is based. And I'm really delighted to be able to launch it today. I don't think I'm breaking any confidential secrets. I won't mention the examiners of her thesis, but I can say that they described her thesis as, and I quote, highly invigorating and thought-provoking, an impressively comprehensive investigation of the topic, and thoughtful, written with sympathy and moderation and very clearly expressed. Well, the same can be said about this book, Mental Health Law, Abolish or Reform. which is published by Oxford University Press. Kay's going to talk about some of the themes in her book, but what she sets out clearly right from the start is her argument that, and I quote, "The future of mental health law demands the embracing of complexity and nuance." And that reminds me of the quotation that I think is attributed to H.L. Mencken, that for every complex problem, there is an answer that is clear, simple, and wrong. Well, Kay's book is incredibly nuanced. So no matter where you stand in relation to mental health law, whether you think it should be abolished or reformed, I highly recommend you read this book. What are we talking about? Mental health laws, as they currently exist in many countries, allow for compulsory detention and treatment of individuals with severe mental health problems. Now, we don't have laws to compel people to be treated for diabetes or epilepsy or cancer. But I think it's worth noting that we do have parallel public health compulsory detention and treatment for infectious diseases, for example. And some places have laws that enable compulsory detention and treatment for those experiencing severe addictions. So in chapter 2 of her book, Kay explains in detail how current legislation across Australian states and territories is based on English law. And she sets out the conceptual basis for mental health law. She talks about its origins in state powers to use coercion, but only if necessary, to protect the public and promote safety, and as well as the obligations on the state to care for those who are perceived as not being able to care for themselves. So our current legislation stems from laws that were enacted back at the end of the 19th century. So while we can say that mental health laws are relatively new, of course, state control of those experiencing mental health problems has long existed. And Kay does a sterling job explaining these historical origins. It was during the rise of the human rights movement in the 1970s that there was also a call for these laws to provide checks and balances over unfettered medical discretion. And I think that's where we are now, that these laws have a human rights framework, but they still enable compulsory detention and treatment. Now, as a former commissioner with the Royal Commission into Victoria's mental health system, on legal advice, I'm unable to comment on our deliberations or recommendations, but I can say that the current Victorian Mental Health Act drew a lot of criticism. And I will draw your attention to chapter 26 of volume 4 of our final report, which critiques the narrow focus on compulsory treatment. And while I can't comment on our recommendations, I can read them to you. So I would like to point out in particular recommendation 42. And on page 36 of volume 4, we say this: the primary objective of a new Mental Health and Wellbeing Act is to achieve the highest attainable standard of mental health and wellbeing for the people of Victoria by promoting conditions in which people can experience good mental health and wellbeing, by reducing inequities in access to and the delivery of mental health and wellbeing services, and by providing a diverse range of comprehensive, safe, and high quality mental health services. Now, that's a very different primary objective to the one in our current legislation. And that's all I can say about that, lest I get into trouble. So back to Kay's book. It provides a well thought out defence of the proposition that mental health law should be reformed And what she argues is that coercion should be decreased, but social supports should be increased in order to maximise the human rights principles of dignity, equality and participation. And she provides what she calls an interpretive compass to understanding the principles and rights set out in the United Nations Convention on the Rights of Persons with Disabilities. And to get to this point, she looks at three main legal models that have arisen since that convention came into force. And I'll leave it to Kay to explain these three models and where she lands. But again, I want to commend this book to you no matter what your perspective is on abolition or reform. It's essential reading, and I don't think it's any coincidence that Kay's research has been published in the highest quality law journals. And now, of course, this book is published by Oxford University Press. And what I particularly like about it is the clarity with which Kay writes. I think there's a tendency for legal scholars to hide behind the objective third person. You know, it is argued that. Kay has the strength of her convictions. She writes so clearly, I argue that, and then sets out the reasons why. So I urge you all to read this fine scholarly book. Kay will now talk about its main themes. So let me declare it formally launched, and please join me in giving Kay a virtual round of applause. Over to you, Kay.
Yes, hello everyone. I'm just going to try and bring up my slides. Okay. Which I was able to do before. Let's see how this goes. Okay, hopefully I can share my screen. Okay, so can everyone see that? Good. All right. Hello everyone. Thank you for joining.
Are you going to share them in that from the beginning version? Because we're seeing the version with the extra slides on the side.
Oh, okay, hang on.
Right.
They seem to be having this problem. All right, perfect. Okay, good. Hello everyone. Thank you for joining us today for the book launch of my new book based on my PhD dissertation, Mental Health Law, Abolish or Reform. So we'll just, it's quite cool at the back there. Okay, thanks. It really seems like forever when back in April, Bernadette and I had lunch, when you could still do that. And we discussed doing this book launch, and not so much with the idea of selling books, although that would be nice, but to really acknowledge the achievement of it, as it's certainly been a very long journey, at least 6 years in the making, but really longer in that it probably incorporates my thinking over the last 12 years that I've worked and studied in the field. And like most achievements, credit for it doesn't only belong to one person, but to a whole range of people who contribute to the work itself, and also to the conditions under which it is made. And in that regard, I'd like to, of course, acknowledge my PhD supervisors, Professor Bernadette McSherry and Diane Otto, for their guidance, advice and encouragement, and for Professor Bernadette McSherry's wonderful launch of my book. And I'd also like to thank all of the comments of my PhD examiners and my Oxford reviewers, and the whole publishing team at Oxford University Press, and my parents, Adriana and Bob, for their assistance with my children. And a shout out to my husband, Michael, and the children, my children, Caitlin and James, who tell me it's quite tough to have a mum who's such a nerd. Unfortunately, though, I can't just sit back and bask in the glory of the book and expressing my gratitude, because this isn't that kind of book launch. I also need to do a seminar, and I've only got 25 minutes. And Mental Health Law, Abolish or Reform is a fairly lengthy book, so I won't be able to go into every point. So what I'm going to do is just give you the headlines. So here's a roadmap of my presentation today. So I'm told that we've got a fairly diverse audience, so I'm going to spend a little bit of time explaining the background to give a bit of context as to how the question of whether to abolish or reform mental health law has emerged and why it's so controversial. And then I'll explain my objectives and my methods and key findings, you know, I guess perhaps filling in some of the gaps of what Bernadette has already explained. So I think Bernadette's probably explained this slide quite well in terms of explaining what mental health law actually means. And it's a pretty broad term. It actually covers all laws, civil and criminal, that relate to mental health. But what I'm specifically talking about today is the Mental Health Acts. And they, at the moment, as they are currently formed, are really pretty, even though they have a whole lot of range of bells and whistles, they're pretty much designed to provide legal authority to involuntarily detain and treat persons with severe mental impairments. And I guess to put that into a wider social context, the Mental Health Acts really relate to a relatively small number of persons who have mental health problems in the population, the vast majority of whom are treated voluntarily in hospital and in the community. So putting it into that context, we can see that about 50% of people suffer from a mental health problem in their lifetime and about 20% per year. And there were 4 million mental health prescriptions in 2016 to 2017. So compared to the millions of people who suffer mental health problems and seek treatment voluntarily, there's probably about 41,197 people involuntarily detained and treated in Australia. That number comes from 2011 to 2012. And on top of that, we've got about a number of people who are treated in the community, but under coercion. And there's about 5,000 Victorians treated per year. And there are similar groups in other states, but we tend to use community treatment orders the most in Victoria. So we have the greatest number here. So that other states have people on community treatment orders, but they're less than 5,000. And the other thing to note is that not everyone, even though there are quite a lot of people who are very unhappy about being treated involuntarily and detained, that's not everyone. So the research shows that there's probably about 40 to 80% of people who are grateful coercive intervention in retrospect, especially if they feel that that the process was fair and that it was actually successful. So I guess that's just putting it all into a much larger sort of context. So why am I looking at the abolition of mental health law? Well, mental health law, as we've stated, has always been very controversial, and there's always been resistance to it, which I chart in my book in the history of it. But the call for abolition really emerged out of the Convention on the Rights of Persons with Disabilities in 2008. And since then, mental health law has been very strongly criticised for being discriminatory and for being an unjustified deprivation of liberty and bodily integrity. So some people who I call abolitionists say that mental health law should be abolished, it should be repealed, and the only thing that we should have in its place is supporting persons with mental impairment to actually make their own decisions. So there's no compulsion at all, although there is a bit of a split between abolitionists. So there's those who say that the Convention on the Rights of Persons with Disabilities requires the banning of all coercion, and those who say that it just requires the banning of discrimination. So some coercion's okay as long as it applies to everyone and doesn't just single out persons with mental health problems. So really in the background to the book is this uncertainty about whether the CRPD requires abolition and what it actually does require. And the reason there is that is because states, parties and disabled persons organisations who were negotiating the CRPD really couldn't agree on abolition, and instead they preferred what Annegret Kampf has called a negotiated silence. So in the actual text of the CRPD, there's no express requirement that says that mental health laws have to be abolished. However, abolitionists still argue that the rights to non-discrimination, equality, legal capacity, liberty, bodily integrity, health, the ban on torture and cruel and unusual punishment, they say that all of these read together actually require the abolition of mental health law. Although, of course, in the CRPD itself, there are only some of the rights in the CRPD, and there's also a whole lot of other rights relating specifically to the right to life and the rights to health that are also there, and lifestyle and things, which they don't really pay a lot of attention to, although I do talk about the right to life in my paper in Human Rights Law Review, and really exploring that and how that relates to mental health law. Okay, so despite the abolitionists saying what they think the CRPD means, at the time of negotiation and since then, many states have really, including Australia and countries like Canada, have given interpretive declarations that the CRPD does not require the abolition of mental health law. And so far, no state has abolished mental health law or implemented full-scale supported decision-making in its place. But, you know, there has been a lot of debate about the CRPD, and there's also been a whole lot of other proposals for less radical reforms that fall short of abolition, but will substantially reform mental health law, and these have also emerged. So why does the call for the abolition of mental health law matter? Especially because politically, states at the moment are very much of the view that mental health law shouldn't be abolished. Well, the first thing is that the CRPD is really the leading convention on disability, which was adopted with 161 signatures and 177 ratifications. So it's not something that we should just ignore. Secondly, the call for abolition really gives voice to a subgroup of persons with mental impairments, and listening to them does promote their dignity, equality, and participation in the process. Although I argue that not all persons with mental health problems are abolitionists. The third reason is that the call for the abolition of mental health law really does provide a useful critique of mental health law, and it provides us with an opportunity to really reconsider its justifications and its goals and how well it's really dealing with all of those things. The next reason is that radical ideas like abolition shift the ground for the entire debate. And that means it makes ideas that have been previously dismissed as being too radical, such as perhaps a shift to a mental capacity model, they suddenly seem a whole lot more plausible when we're talking about getting rid of the whole thing. The CRPD has also sparked widespread mental health law reform activity throughout the world, and it has started to influence the development of case law. And even if the CRPD does not require abolition, which I argue it doesn't, there are two questions remain. And that really is, how should the CRPD be interpreted? And what does the CRPD actually require states to do? And really only the most superficial reading of the CRPD would conclude that states are not required to do anything at all. So I've got two quotes that I'm going to put to you that kind of, I think, perhaps demonstrate the tensions that I've been talking about that have really happened since the CRPD has been introduced about what the future of mental health law should be. And the first quote I've got here comes from the CRPD committee in General Comment number 1, which is itself quite controversial. And the CRPD committee are the committee that are in charge of implementing the CRPD and, you know, giving guidance about its interpretation. So this is what they say. They say states parties must abolish policies and legislative provisions that allow or perpetuate forced treatment, as it is an ongoing violation found in mental health laws across the globe, despite empirical evidence indicating its lack of effectiveness and the views of people using mental health systems who have experienced deep pain and trauma as a result of forced treatment. So that's sort of one abolitionist type view. Then there's another view. And this quote I've got here comes from someone called Graham Morgan, who's a person who's been diagnosed with schizophrenia. And it comes from a paper by Gillian Craigie and colleagues. And what he says is this. He says, look, for me, compulsory treatment in the community probably keeps me alive. And yet I'm aware that there is limited evidence that this form of intervention is effective. However, I think there is ample evidence that detention in hospital when desperate, when you cannot bear another day, when the television is beaming horrific messages and instructions into your brain, is needed. If left to exercise my legal capacity, I would have died, and no peer support, no compassionate friend or loving professional, no aspect of open dialogue or eCPR would have made any difference. Yeah. So in light of the debate that's been going on and the various tensions, the objectives of my book were to really take a deep dive in terms of looking at the whole issue about whether mental health law should be abolished or reformed. So as Bernadette's already pointed out, I wanted to examine the history of mental health law and the call for its abolition and you know, why we are where we are now. Where has all this come from? The second thing that I wanted to do was to create what I've called the interpretive compass of dignity, equality and participation. Now, dignity and equality and participation are really important human rights values which really underpin all of human rights. And I felt that by looking at those things, I could produce a more holistic interpretation of the CRPD and perhaps try and find a way through the impasse between abolitionists and states parties. And in looking at the meaning of dignity, equality and participation, I'm kind of using sort of a deep jurisprudential sort of ethical analysis, drawing on a whole lot of different disciplines, from philosophy to psychology, medicine, but also, you know, disability studies. So I'm looking at a wide variety of materials, as well as things related to the negotiation of the CRPD itself. Then I wanted to use this interpretive compass that I've looked at to compare the abolition with support, which is abolishing mental health law and just replacing it with support, the mental capacity with support models, which involves actually looking at people's actual mental capacity through assessment, but also providing people with support so that that can assist them in making a decision, and also allowing people who do have capacity to make decisions, which will be respected by law. And the support except where there's harm models, which is really the idea similar to abolition with support. That is, support is what's provided as the norm, but there's an exception where there's likely to be harm from a decision a person's making. Okay, so where does this whole interpretive compass come from? Well, it comes from the CRPD itself. So I really refer to Article 1 of the CRPD, which provides the object and purpose of the CRPD, which is to promote, protect and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote the respect for their inherent dignity. So we can see here that inherent dignity is a really important value that is underpinning the CRPD. Now, I'm not going to go through all of the general principles in Article 3, but I do want to just point out a couple of things. Once again, we can see inherent dignity appearing, and also the individual autonomy, including the freedom to make one's own choices and the independence of persons. We can also see that non-discrimination and equality comes up as well. And participation is an important value, hence why I chose it. But we also see human diversity and preserving identity, which is also something that I see as being very much part of inherent dignity. So that's where it all comes from. And to explain the importance of those general principles, I've got a couple of quotes here. And so the first one comes from Oliver Lewis in Bernadette's book, Rethinking Mental Health Laws. And what he says is that the principles represent the moral basis of the CRPD, explaining the reasons for its existence and providing guidance for national authorities, courts, and the treaty monitoring body on how to interpret the CRPD. And going back to Gillian Craigie's paper, she also includes a quote about this, and she says, and when I saw this quote, I thought really, and I was finishing up writing my PhD at that point, I thought this is actually part of what my PhD is really looking at. And she says, look, it's unclear how the step from these principles in Article 3 actually came to the conclusions in General Comment number 1, that sits behind the conclusions in General Comment number 1, that mental health law should be abolished, was made. And then she says, indeed, it seems plausible that the application of these principles might sometimes yield conflicting guidance that would need resolution. The requirements to respect inherent dignity and value the independence of persons, for example, do not always point in the same direction, which I definitely do argue that. And much depends on the situation that is being considered and how these principles are understood. So this is what Bernadette was saying. This is my main contention and finding in my book. And that is that contrary to the arguments of abolitionists, mental health law should not be abolished, but be reformed by decreasing coercion and increasing social support to persons with mental impairments to maximise their dignity, including autonomy, equality and participation in accordance with the overall object and purpose of the CRPD. So what do I talk about in the book? Well, as Bernadette's mentioned, she actually talked quite a lot about the history of mental health law that I talk about in my book. So what I argue in relation to that is that contrary to the claims of abolitionists, my book demonstrates that mental health law has not stayed the same, but has actually always been in a state of continual reform. And the call for abolition could be even thought of as being the latest iteration of that. I think that abolition on its own is potentially self-defeating, and that the reality really lives up to the rhetoric. It's created and held up as being this, wonderful and perfect solution that it may not necessarily be. It may have all sorts of unintended consequences. So instead, I think that incremental change through reform is a much more preferable way of going. The next thing I talk about is the emergence of the call for the abolition of mental health law and where this all comes from. So the book traces the resistance to mental health law throughout history, but especially as part of the civil rights movement in the 1950s and 60s, and including things like this anti-psychiatry critique as well, which was initially a large part of the movement. It demonstrates that mental impairment does not neatly fit within the broader disability rights movement. It actually came quite late to that movement, and there are still plenty of people who have mental health problems who don't actually see themselves as being disabled, and other people like Anne Plum who are critical of the disability rights movement because they feel that it perhaps was more developed and to fit people who have different kinds of disabilities, so people who are more so with, say, wheelchair users and physical disabilities, without necessarily properly taking into account some of the issues that people with mental health problems actually have. And it also identifies the key concerns of abolitionists. So, I go into this into quite a lot of detail, so that, mental health law is really about social control, this issue of discrimination, unjustified interference with liberty and bodily integrity, torture and cruel and inhuman treatment and punishment, that mental health law is ineffective and untherapeutic, that there are better alternatives. And I look at where those critiques have come from historically, so we can think about different ways that they can be addressed, and whether they can also be addressed just as well and maybe better through reforms. And I felt that this deep analysis is really necessary to show that I actually do understand the call for abolition and that I haven't just created a straw man. So that's really part of it as well. But this is an interesting chapter, and I think, no matter where you fall in the debate, that a lot of people who perhaps are in the abolitionist camp might still find this chapter quite interesting and something that they will find useful. So in terms of my interpretive compass, I've created this way of interpreting the CRPD, looking at dignity. So what did I actually find, and what did my research reveal about the meaning of dignity? Well, that is that I felt that inherent dignity includes, but actually has a wider meaning than respect for autonomy. That autonomy, it's a state of fact rather than a right. And creating the conditions for autonomy, such as providing support, is not the same as ensuring actual autonomy. So I found that dignity includes recognising a person's intrinsic human worth, equal treatment, behaving with dignity, being treated with dignity, and respect for autonomy where that does not threaten inherent dignity. So you can see that dignity includes a whole lot of different things, and autonomy is just one part of that. I also did find, though, that there is undignified treatment of persons with mental impairment by the mental health system, and this is something that really needs to be addressed by legal and systemic reform, and there is an enormous amount of work to be done on that. So we can't ignore those criticisms. They are very important and real. And also, the book explains what dignified treatment is, and gives some details from the research about what that might involve. So looking at equality. So what did I find when I was looking at that? Well, I found that equality and non-discrimination and what it means in the CRPD is actually unclear. I felt that the CRPD contained a very eclectic and incoherent model of equality and non-discrimination, in which it's kind of like, well, we just outlaw every kind of inequality and form of discrimination, no matter what. And it kind of ignores that there are potentially some, inherent tensions between different kinds of equality and non-discrimination and what they actually mean. So, for instance, there might be tension between formal equality and treating everyone the same, but also then taking into account their differences and trying to create substantive equality or transformative equality. So what I found is that equality is broader than treating persons with and without mental impairment the same, and that abolishing mental health law without recognising the effect of mental impairment on the person may have the effect of exacerbating rather than creating equality. So as we can see here, just popping people up, even if they're starting at different heights, actually isn't going to be equality, but sometimes we need to do a bit more for some people to create equality. And I also looked at supported decision-making, which I think is extremely exciting and certainly something that requires a lot more research, and is something that can be used in a whole lot of different models. And all of the models that I'm looking at do use supported decision-making. But I felt that on its own, it may not be sufficient to guarantee equality. So in terms of the interpretive compass, I look at participation. And participation is an important principle, and it means being consulted about and having one's views taken seriously in the decision-making process. So it's certainly a very important part of the disability rights movement with the nothing about us without us catch cry. And it applies to individual decisions about a person's individual health, but also at the policy-making level as well. But it doesn't mean that states parties have to do whatever persons with disabilities say without taking into account any other interests. And I think we should acknowledge that sometimes a person's level of participation may vary according to their impairments. And that disabled persons' organisations may not always be representative of all persons with mental impairments, and that many persons with mental impairments agree with the use of mental health law, and they feel that they've been sidelined by abolitionists. So basically, using the interpretive compass, I've used that to apply to 3 models, and I've used the interpretive compass to present a critique of the abolition with support model. But obviously that's not enough. If I say that we shouldn't abolish mental health law, well, what should we do? So I need to look at reform as well. So I analysed what I think are probably the 2 current reform options. And one of them is what I talked about before, the mental capacity with support model. And the other is support except where there is harm model. And I use the interpretive compass to look at that. And of the 2, I argue in favour of reform using the mental capacity with support model, because I felt that it really was the model that perhaps most recognised inherent dignity, equality and participation, and it gave some room to also recognise autonomy as well when people have mental capacity, and they've been given a lot of support to help them really understand and make their own decision. I suggest improvements to the mental capacity with support model though, as it's been currently done, and I think that more needs to be done to ensure that proper support is actually given, to improve mental capacity assessment, to give more weight to individuals' will and preferences, to improve treatment options, and to improve safeguards such as judicial oversight. But I also really, while the focus of the book really is on this issue of whether mental health law or whether involuntary detention and treatment is ever justified, I do give some consideration to the importance of systemic and social reform, especially resources, which are really important to actually give people real choice and options, so they've actually got something to choose, and to lead to more individualised care and medicine. And that's probably more in line with what the Mental Health Royal Commission and what Bernadette was saying before about, changing the focus of mental health law to also include just improved services and ranges of services and choices as well. And so in doing the analysis that I've done, what the Mental Health Law Abolish or Reform tries to do is really create a much broader vision of mental health and disability rights that really includes, understanding all of and including recognition of all of the rights that people with disabilities have, their rights to liberty and their rights to liberty and so forth, which is pushed by the abolitionists, but also their rights to life and health as well. So really, I guess we're at a point where we can ask some questions.
Thanks, Kay, for racing us through the extended argument that you've provided in the book. I think it probably will have provided stimulus for people to think about buying it, which will be good, and engaging with it. We've only got time for a couple of questions probably, and I might use my privilege just to clarify one thing that I was curious about myself. You were mentioning that the general comment 1 is quite frank in talking about no force in the document, but your key point about abolition being self-defeating made me wonder, if you know where abolition has been tested, have you got a sort of empirical foundation for saying that it's self-defeating?
Oh, okay. Well, I guess it is a claim. What I talk about a bit is I also refer back to, the abolition of institutionalisation as perhaps being a first abolition. And we saw from that, there were a lot of unintended consequences. And obviously it's still on a very important and ongoing thing that still needs to be implemented. So, yeah, I don't necessarily think that is necessarily going to have the results that people think that it might have. It may have other unanticipated consequences. So, I mean, we certainly saw when deinstitutionalisation was first introduced, there were a whole lot of issues there with people, going from institutions and ending up in prison, transinstitutionalisation, and just neglect.
Mm-hmm, mm-hmm. Yeah, so you're picking up on the ends kind of issue that might arise. I hear what you're saying there. And I've just noticed somebody's put a question here that is phrased as a question. So, or two people have. Coercion is not treatment. Yeah, sorry. Coercion is not treatment, is enabling treatment, which hopefully is a person appropriate. Is there confusion between positive and negative freedoms and human rights? Is that something that you perceive?
Yeah, I think there is. And I guess we can even see it now with what we're all going through as well, that there is sometimes a sense of perhaps you need to temporarily suppress people's freedoms with the view that they'll get greater freedoms down the track. And that certainly has been successfully used before we had Delta. We certainly were able to do that by getting back to COVID zero and opening up and, pretty much having a normal life. Apart from border closures.
Yeah, which is a public health intervention, but there is this issue of equity to some extent there, isn't there, that everybody was subject to those same coercive forces.
Yeah, and I think that there's also positive, I do talk about that in the book actually, positive freedoms as well. So the freedom, I suppose I'm concerned not just about negative freedom, which is the right to be left alone, but also the positive freedom of being able to give people a better life. And actually, participate in life and be part of it, and not really fall by the wayside.
Thank you. I think we've got a minute or two that we could keep going with. If somebody wants to put up a hand or pop another question in the chat, you're welcome to do that. I guess that was something that struck me as one of your sort of concluding points, and probably the reason I feel like reading your book is to have a look a bit in detail at the way you've unpacked this models re mental capacity with support versus support except when there's harm. I'm quite interested to sort of dig into that argument and understand a little bit about what's sort of sitting behind that as a headline. So there you go, flagging my...
Yeah, I didn't really have a lot of time to go into that, the details. I thought it might get a little bit technical and boring as well. But I also do talk a bit about that in some of my papers too, but probably in the book, I'm very much part of that.
I've got a couple of practical questions coming through, or quite specific ones, which I think we can handle. Ali's asked, where the statistic came from that you mentioned that something between 40 to 80% of people are grateful for compulsory treatment.
Yeah, okay, well, that's just not really from one study, it's from a whole lot of different ones. So yeah, I can't really tell you off the top of my head what they all are, but it is set out in the book. And
do you know if any of those are local, Australian, in your recollection?
I'm not sure if they are Australian or not. Yeah.
Or it must vary a lot depending on how, definitions are cast.
Yeah, there's a lot of research on this issue about whether people are grateful in the end or not. So yeah.
Somebody else has asked, more thinking about people's experience, and that might be a good place to land towards the end of our time today. But Zara said, I'm really interested by consumer involvement in your book. Did you consult with those with lived experience of compulsory treatment as part of your research?
No, there wasn't that kind of research. So I didn't do any interviews or anything like that. What I was looking at was, a lot of the published materials and research that's out there. So that's where I got that from. And there is quite a lot. So I looked at all of the research. So I looked at the research from people who are consumer-led research. And I also looked at a whole lot of other research as well. So
in terms of being applied and in the sector, somebody's made the comment, how might alcohol and other drug sector also integrate or interact with a mental capacity with support model? Does your work touch on that beyond the mental health sector per se?
Not really. I haven't really got into that at all. But I imagine that if the person reads the book, they might see the parallels because, there are.
Great. Well, I think that takes us almost precisely to time. It has been an absolute romp through what's obviously been, work that's completely preoccupied you for, all of the 6 years I think you were mentioning. So hopefully you've got this fantastic sense of rounding something off in the process of the launch today, Kay. And I'm sure everybody would like to join me in congratulating you on your extensive efforts. Thank you. So that kind of does pretty much conclude the formal part of our session today. There are lots of people giving you claps and chat and congratulations in the chat, Kay, but some people might like to, turn their cameras on and unmute and sort of speak to you. So let's just say that that's what we have time for now. I can see some celebration hands and so forth. I'd like to thank Bernadette as well, and obviously the Institute for hosting and bringing about the event today. And of course we do have several more seminars lined up, for the coming months. So keep your eyes peeled, everybody, on this really interesting and important series. And yeah, congratulations once again, Kay. Thanks, everybody. Feel free to